Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefields of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. Thank you so much for joining us today. Okay, I cannot believe we're in the second week of October. Where is the time going? My daughter is going to homecoming, and she has a big horse show this weekend, Ella. So, the time is just flying by with her. I feel like I'm on borrowed time for her going to college. We'll get into that at some point. But for now, for today, we are going to talk about remote work as a reasonable accommodation. And this is a really important topic for a couple of reasons. And I feel like I say that every week. Oh, this is a really important topic. But honestly, I only talk to you about important topics, okay? I only want to take your time when you are very busy, and you can be very picky about what podcasts you listen to and where you get your information. I only want to tell you things that are important. So I guess I should stop saying that because everything is important. But this really is important. And here's why. Back when COVID hit in March of 2020, many of us, to help our employees and frankly to help ourselves to stay in business, we sent people home. Now, as you probably know, we were at that time doing Wednesday Wake Up with Jen, where we had a free webinar for employers every Wednesday where we talked about COVID rules because those darn things changed just about every hour. And we all needed to stay on top of what was going on. And so we would meet every Wednesday morning for an hour and a half or so. We'd go through everybody's questions. We'd make sure we got done. And we were ready to roll for the next week. What was happening during that time is a lot of people were teleworking, but not performing the essential functions of their job. So we said, hey, it's okay for you to work at home. Let's just do what you can at home in the middle of trying to tutor your kids if they were homeschooling or they had to do video school and figuring out how you were going to get groceries without getting sick. And in my case, before they figured out that COVID wasn't carried on a package, wiping down all my groceries. I mean, we all came up with very interesting ways of coping with COVID. The lasting effect of COVID from an employment law perspective is telework. Everybody is dealing with this issue where employees are saying, I want telework. And when you say it isn't a reasonable accommodation, they say, well, isn't that interesting because you let me telework during COVID? And one of the things I recommended during COVID was saying to people, hey, listen, we're going to let you telework, but we want to make sure you understand that you're not performing the essential functions of your job. You're not able to do everything you need to do from home. For example, when our staff was teleworking, Ronnie, our chief operations officer, and I were here getting the mail, making copies, doing all the admin type stuff that needed to be done. People couldn't do that from home. So there were aspects of people's jobs that weren't getting done at home, but that was okay because we wanted everybody to still get a paycheck. We wanted to still be able to help our clients. We made that decision to let them work at home. Now, these days, we don't want most people to work at home. We just hired someone who's going to be working exclusively on investigations, and she's going to be working at home. But generally, our admin staff need to be here every day. We have clients coming in. We have phone calls. We have all kinds of things that need to be done. My point is, employees have developed a sense of entitlement in terms of teleworking. And so a lot of employers are dealing with when is it actually a reasonable accommodation? Well, recently, the Federal Equal Employment Opportunity Commission gave us a little bit of guidance on religious accommodations. Okay, now remember, under the law, there are two things we have to accommodate. A medical condition that constitutes a disability, either under the Americans with Disabilities Act, which is a federal law, or applicable state law, like California's Fair Employment and Housing Act, or a religious belief that is protected under Title VII of the Civil Rights Act on a federal level, and again, the Fair Employment and Housing Act here in California. there hasn't been a lot of discussion of religious belief accommodations relating to telework. Because if you think about it, what would be the rationale? Why would somebody need to telework for a religious accommodation? It doesn't come up much. Now, we've had a few, like somebody says, I live near my church, and on Wednesday nights, we have a service that starts at 5. If I'm at the office, I can't really get to the service on time. On Wednesdays, could I work at home, or could I leave early, maybe at lunch, and go work at home in the afternoon so that I could get to my church service? That might be a reason somebody would need to telework as a religious accommodation. But generally, we see teleworking when it comes to medical conditions, to disabilities, right? I need to telework because I am too susceptible. My immune system is too fragile. I can't be out in public, so I need to work at home. One of the interesting things that has been litigated quite heavily is, do you have to accommodate somebody who says, I can work when I get to work, but the commuting is what I can't do because of my condition? So let's say I have a back problem. I can't sit in the car for an hour and drive to the office. Once I get to the office, I could certainly do my stand-up desk, right? But I need an accommodation because I can't get to work. That issue has been dealt with pretty clearly outside of California, where the court has said under the ADA, many courts have said this, under the Americans with Disabilities Act, you don't have to accommodate somebody's commute. It's a little less clear in California. We don't have a great case that stands for that proposition, although that is certainly what the California Civil Rights Department has said. Anyway, here's my point, everybody. These telework accommodation requests can be tricky, okay? And when the EEOC issued their recent guidance on telework as a religious accommodation, they called it situational telework. So is there something of situation that needs to be addressed for your folks who have a religious belief or practice? And what I want you to think about, first of all, is how to distinguish between what we call a flexible work arrangement, hybrid. You can, in your discretion, you can choose to work at home when you want to work at home, and legal accommodations, which are, of course, mandatory if they meet the requirement for being reasonable. So if you have a situation, for example, where somebody says, I need to telework because there's no way for me to get to the office without flaring up my medical symptoms, right? So you have to look at, well, first of all, is that actually accurate? Do we have a medical necessity here, right? If it's a medical issue, which in that case it is, do we have a medical issue? Is the accommodation, teleworking, going to be effective to let that person do their essential functions? Interesting, important factual issue. And then we look at the third element, does it impose an undue hardship on the employer? Okay. And so the EEOC guidance said, listen, you're going to look at similar issues when you are evaluating telework as a reasonable accommodation for religious belief, but you're not going to look at whether it's medically necessary. Obviously, it's not a medical accommodation. What you're going to look at, is there a conflict between working on site and their religious belief or practice? So, for example, somebody might say during Ramadan, I need to be able to pray frequently during the day. I need to be in a more solitary space. I need to be in a more reflective space, and I want to be home. And then we have to look at, okay, is there actually a conflict between their ability to practice those religious beliefs and coming to work on site, in the office, on location, whatever it may be? So one of the things I really want you to think about is, if you have a flexible work arrangement or policy where you let people decide where they want to work and when they want to work and those sorts of things, don't call it an accommodation. Don't go down the road of a medical accommodation, a disability accommodation, or a religious accommodation if what you're doing is just deciding how the hybrid work schedule is going to work. Okay? So that's really important. Don't create an interactive process obligation. don't create a reasonable accommodation analysis if you don't have to. If you're just going to grant it under your policy of a flexible work schedule, then just do that, okay? If you're not, if it truly is an accommodation, one of the important things to think about here is your documentation. And I feel very strongly that you should have a log. It can be an online log. It could be something that you have in a notebook. It could be on your phone. I don't care. But it needs to be something where you're recording, all right, what conversations are you having? Are you doing email exchanges? What is the employee asking for or the applicant? What documentation have you requested? What documentation have you received? Was the documentation satisfactory? Right? You need to go through all of those questions and issues and then document it for a couple of reasons. Number one, if it's not written down, it didn't happen. Okay. And what I mean by that, not literally, but if you're trying to defend a claim and you say, well, I did engage in the interactive process. I called Jen 3 times and we had lengthy conversations and she said this and I said that. Where's your documentation? Right? Do you have something written down, by the way, that doesn't just say what you said, but what did the employer or the applicant say as well? You need that documentation. Second of all, you need to know where you've been so you can be consistent and fair to your applicants and employees. If you deal with each of these as a one-off, which you need to do, of course, but then you don't document what you did and why you did it, it's going to be very difficult for you to ensure consistency and fairness. Now, remember, there's a difference between equality, right, and treating people the same, right? Equality is you're being consistent, you're being fair, but you're not necessarily treating them equally, right? Equally is not the same thing as equality. When we talk about treating people the same, it's going to be very rare that any two accommodation situations are going to be exactly alike. You're going to have different fact patterns. You're going to have different expectations. You're going to have different job duties. There's just going to be different circumstances in just about every one of these. But you need to document so you are clear what you've done and why you've done it. And like I said, you could do it in a spreadsheet. A lot of you have asked over the years, well, Jen, is there a good software program that does this? Don't I wish? Don't I wish there was a great software program? Every time I go to a conference, I go to the booths, I go to their leave management booths. I try to talk to people about what are you doing to manage leaves? What are you doing to manage accommodations? And none of it is satisfactory. I just have to be honest. They're just not providing a full, comprehensive program. If they ever do, I'll be the first one to recommend it. I also want to make sure that you're training your leaders. Because remember what happens when we talk about accommodations. We all have our own perspectives, our own views. Look, everybody in my office knows I am not a good remote worker. When I'm at home, I want to do my laundry, cook, hang out with my daughter, reorganize the closet, water the garden, play with the puppies, go to the horse barn. I don't want to work. I do really well in the office because as I'm coming up the stairs to our office on the second floor, I'm getting in the groove. Like I know, okay, I'm at work and this is what I'm going to be doing. And at night, when I walk down the stairs from the second floor and out the door to my car, I'm getting in the groove of being home. What are we going to have for dinner? What is Ella up to? Do I need to shuttle her anywhere? What's going on? Check the mail, pay the bills, all of that. That's all going to happen at home. So I'm not good at being a remote worker, but many people are. And I think almost all of the attorneys in our office, except for me, they all partially work at home, right? They work a hybrid schedule. Maybe they're here Monday, Wednesday, Friday, and they're home Tuesday, Thursday. I don't have any problem with that at all. It works for them. As long as they get their work done and they bill their hours, I don't care. That's fine. I'm just not good at it. So when you're talking about people teleworking, you also have to remember you have to assess whether they can actually do it. Are they successful at doing it? So if you approve remote work as a reasonable accommodation, don't do it indefinitely. Don't tell them they have that accommodation forever. You tell them, let's try it for 30 days. And then you've got to train your managers, as I was mentioning a moment ago, your leaders, so that when somebody comes to them and says, hey, can I work at home 2 days a week? If that's consistent with your policies and your practices to have a hybrid schedule, then we don't want them, your managers, your leaders, to turn this into an accommodation issue, right? They should not be considering it an accommodation. I don't want anybody writing an email saying, well, we've approved your 3-2 schedule as an accommodation, unless the accommodation was required under the law, okay? So when we talk about these accommodations and we talk about remote work, I just want you to be really clear when you have to consider it to be an accommodation, right? And if it doesn't have to be an accommodation, then don't let it be an accommodation, right? Let's just figure out exactly what we need to be doing so that we're giving employees what they need, we're getting the work that we need done, and there's not any kind of a problem. If it's not a policy or practice you're doing, then I want you to make sure that you are looking at this as an accommodation. And if you look at the EEOC's guidance in this area, it is very important that you look at the situation, right? You should make sure that you take a look. It was issued on August 22nd, 2025, okay? It's focused on religious liberty protections, but the whole idea is how you are going to evaluate whether something is a reasonable accommodation, particularly remote work. And they look at this idea of undue hardship in a very specific way. So I want you to take a look at the guidance. Again, in California and other states, we have more protections, but certainly the federal law is a minimum standard. So if the EEOC is telling us to do something, we definitely need to look at it. Everyone, thanks for joining me here today. Go out and have a great day, and we'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.